Good afternoon. We're here on the court's afternoon calendar. This is the motions calendar, criminal motions calendar. I'll call the case to see if everybody's still prepared to go forward. Position 1, Jeanette Jimenez, motion to modify bond.
Good morning, or good afternoon, Your Honor. Attorney Render here on behalf of Ms. Jimenez. I did speak with Ms. Miller. She did provide an offer. If I could speak with Ms. Jimenez briefly, less than 2 minutes, I believe I can relay that to her and give an announcement.
Okay, position 2, Jonathan Moorhead, motion for bond.
Good morning, Your Honor. Yes, Your Honor. If I could speak with my client as well, I do have a new offer from the state, and I think this case will not require hearing.
Okay, position 3, Emmanuel Armstrong.
Good afternoon, Judge. That's my case, Kenneth Mohammed. We will be going forward with the bond hearing. I do need an opportunity to speak with my client as well.
Okay. Position 4, Dantavius Wright, is a plea today.
Yes, Your Honor, we're ready to proceed.
Okay, position 5, Deangelo Barlow, is that still a plea today?
Yes, Your Honor, it is a plea and we're ready to proceed.
Okay, very well. For the 3 attorneys on positions 1, 2, and 3, I'm going to open up the breakout rooms because it's just a single jail pod. You'll just have to call your clients up when you're ready. Am I freezing?
No, it looks like you're fine, Judge.
Okay. Okay, jail. Can you guys hear me there, Mr. Riley?
Yes, ma'am, we can hear you.
Okay, good afternoon. I'm going to open up the breakout rooms and the positions 1, 2, and 3. Jeanette Jimenez, Jonathan Moorhead, and Emmanuel Armstrong need to speak with their lawyers, and they're 3 separate attorneys.
Yes, ma'am.
Okay, go ahead.
And Judge, I apologize. I do believe Ms. Reddick and Mr. Mohammed and I do need to approach at some point after they get back from speaking with their clients.
Okay, very well.
And Your Honor, position 1, Jeanette Jimenez, we are ready to proceed with the bond hearing.
Okay, I see the jail's back. I presume everybody else is. What's the announcement on position one, Mr. Render? Are you ready
That'll be
to
a
go forward?
brief, yeah, that'd be a brief 5-minute hearing, Your Honor.
Okay. Ms. Miller, you indicated that you needed to be in a breakout room with Attorney Muhammad, is that right?
Yes, and Ms. Reddick, as well as yourself, Your Honor.
Okay. All right, let me get the announcement on position two, Jonathan Moorhead.
Judge, we're going to withdraw our motion for a bond and set this up for a plea.
Okay, very well, withdrawn. Is that all you have for today, ma'am?
That's all I have. Yes, Judge.
You're free to go. Okay, you all, I'm gonna open up the breakout room. I'll join you there in a moment. Position 1, Jeanette Jimenez.
Yes, Your Honor.
Let me wait for your client to get to the podium.
Hold for me, please.
Okay, the state of Georgia versus Jeanette Jimenez, case number 2020 CR 01682. Mr. Render, this is your client's motion to modify bond. You may proceed.
Yes, Your Honor. As you stated, Your Honor, we are here for Ms. Jimenez's motion to modify bond. Ms. Jimenez has been incarcerated almost 20 months at this time. It is a situation by which she has not been able to make financially the $150,000 bond that is in place. So for proffering a standpoint, Your Honor, she does have a bond. It's not a situation where you'd be granting a bond and one that state has not provided one. We're just asking for a reduction for financial reasons. Again, she has been in almost for 20 months. This is her first felony. Now, she does have a litany of misdemeanors in our candor outside of the state of Georgia. But as far as felony charges go, I did confer with A.D. Miller, and if I'm incorrect, Ms. Miller, please direct me in the right direction. But from my understanding, this is her first felony, although it is trafficking. And we understand the level of quantity of drugs that would make it trafficking. We understand the nature of the crime, trafficking, which would make $150,000 bond put in place, which would have made the bond put in place 2 years ago, Your Honor. But what we're asking for now is a reduction down to $75,000. She was working at the time doing Uber. From my understanding, she would be able to continue doing that. She does have a family in the area. She is 40 years old, Your Honor, so she has gone through her life without picking up a felony. So I don't anticipate her committing any new felonies pending trial. I don't see her being a significant flight risk. I don't have any indication of any FTAs or bench warrants on her record. If the court is inclined, she is in an agreement to any house arrest or home monitoring with the reduction in the bond so that she's able to make the bond, get out, and procure funds to, pay for the ankle monitor. Again, Your Honor, she has been incarcerated for almost 2 years. And for this reason, we're asking for a reduction in the bond for financial purposes.
What day was she arrested?
If you give me 1 second, Your Honor.
He was arrested on November 7th, 2019.
And Ms. Render, is this your motion? Do you have one that has no caption on it?
No, it should not be. I filed electronically, Your Honor.
Okay.
The
So-
one I have from him does have a caption.
Okay, what was the date again?
It was November 7th, 2019.
$19 months.
Okay. Anything else, Mr. Render? Was that it? Ms.
Nothing
Miller?
further, Your Honor.
Judge, as Mr. Render has stated, she is approximately 40 years old. The facts of this case do come from a late 2019 incident wherein law enforcement were investigating trafficking through the Atlanta airport. At that time, they did identify the co-defendant as flying in on a flight from Los Angeles with luggage that they suspected to have marijuana inside of it. They subsequently did retrieve that luggage and approached the co-defendant, who at that point pointed them to Ms. Jimenez. She was also present at the location, and the co-defendant advised that she has been transporting marijuana. However, each time she has brought it to the Atlanta airport, she has met with Ms. Jimenez to hand it over, and she advised that this has occurred approximately 5 to 7 times. On further investigation, law enforcement did obtain the cell phone of Ms. Jimenez and review her cell records, which did corroborate the co-defendant's statements. There were at least 3 separate dates of messages regarding her picking up marijuana at the airport, as well as corresponding photos and price lists, which indicated that she was engaged actively in the distribution process of marijuana, that this wasn't an incident where Ms. Jimenez, at least, is not a mule transporting on behalf of someone else, knowingly or partially, unknowingly, but that she was actively engaged in the distribution and transport of marijuana across the country from California. She does not have any felony criminal history. She does have some misdemeanor offenses out of California. The state's contention is that she is a potential flight risk, being that the majority of her ties are to California and that she is facing, these serious charges in Clayton County. We do understand that her bond has been at $150,000 for a substantial amount of time. We had been working with her prior counsel before Mr. Render was retained, trying to discuss some plea negotiations, but those did fall through. At this time, Your Honor, the state is asking that if Your Honor is inclined to reduce her bond, that it be reduced to $125,000, and that it include an ankle monitor condition to ensure her presence in court if she is released on that bond.
Anything further, Mr. Render? She was an Uber driver in California or in Georgia? Did she live here?
Yes, Your Honor. We can provide a address in Georgia.
Where does she live? What city?
She lives in the metro area, Your Honor. She lives with a cousin.
What city?
Ms. Jimenez?
Yes. It was
Just
done. It was done with it.
I can't.
Dunwoody, Your Honor. Dunwoody, Your Honor.
Dunwoody, is that correct?
Yes, Your Honor.
Miss Hernandez, is that correct?
Jimenez.
Is Dunwoody correct?
Yes, Your Honor.
Okay. How long has she been there?
Your Honor, that's where she was staying, from my understanding, prior to her arrest, for a few months.
Right, so what's her significant ties to Georgia?
The family members that she was here staying with before she was arrested. She does, again, she is from out of state, but she was in the area living with the cousins that are referred to, one of which stays in Dunwoody.
Okay.
And I was just going to state, Your Honor, if the court has any, I can get that direct address if the court needs that direct address proffer.
No, I was about to rule on your motion, sir.
Okay, thank you.
I'm going to reduce the bond to $100,000. There will be an ankle monitor and there will be a curfew. The curfew is 7:00 p.m. to 7 a.m. Which means that means, ma'am, you have to be home from 7 p.m. to 7 a.m. Anything else in this case?
Nothing further, Your Honor. We just thank you for the reduction. And Ms. Jimenez, I'll be at the jail to see you.
Yes, sir.
And that
Position,
concludes my business, Your Honor. May I be excused?
you may.
All right, you all have a blessed day.
Get to position 3, Emmanuel Armstrong. May I have Mr. Armstrong? State of Georgia versus Emmanuel Armstrong, case number 2021 CR 00931. This is Mr. Armstrong's motion for bond. Mr. Muhammad.
Yes, thank you, Judge. My client is currently charged with aggravated battery, aggravated assault with a deadly weapon, cruelty to children, possession of weapon, and possession of firearm as a first offender. We're asking for bond, for the court to set the first bond on these 6 charges. He's been in custody continuously since July, since the incident happened, without being granted a bond. And just to give the court some indication generally as to what the facts entail, the incident occurred at an apartment complex. My client, who is 35 years old, went to visit a friend of his that's 31 years old. The friends, during the discussion, 17-year-old brother came out and essentially, because of some past issues, this is what the defense alleges, and I'll modify it to state how the state is presenting it. The defense alleges that the 17-year-old came out with a firearm and attempted to point it at my client. There was a struggle, and the 17-year-old was shot in the leg. There is a 13-year-old that was there as well. The 17-year-old and the 17-year-old gave a statement initially to officers stating that somebody came by and shot him and he doesn't know who it was. Then his mother called him, according to the police, and she heard the mother yelling at him. Then the mother arrives, and after the mother arrives, he gave a new modified statement and identified my client as the shooter, and said that my client just showed up at the house, knocked on the door, pulled out a gun, and then shot him, basically shot him in the leg for no reason. And the 31-year-old brother didn't give a statement at all. There are multiple individuals that were there. We do contend that if this matter goes to trial, that there will be several witnesses that we will gather. We know of at least one, as I've indicated to the court now, that is outside of custody, that corroborates my client's version of events. As I indicated, my client is 35 years old. At the time that the incident happened, he was working 2 jobs. Each of them he had for over 1 year. One job he had was changing tires at Wheels and Tires. Another, he worked inside of a restaurant called Beeline. If the court, his hours were essentially all day. He worked more than 12 hours. He believes that both jobs are waiting for him if the court does grant bond. He would live at an Atlanta address where his mother resides. If the court grants bond, I could give the court that address. I do have it here. My client does have 2 past felony convictions. In 2004, he was convicted of possession of firearm, felony obstruction, and voluntary manslaughter. He served a 10-year sentence on that particular charge. The only other conviction that he has is an obstruction of law enforcement officer and a burglary from, I believe that one is 2011. And he also had 1 misdemeanor conviction as well. But Judge, given the length of time that my client has been in custody, the indictment was just entered a short time ago. The nature of my client's defense, the fact that the victim's elder brother, who's 31 years old, was standing right there and won't give the police a statement, is strong reason why I believe that the court should, and this is all in the police report, that the 31-year-old refused to say what happened. We believe that's strong evidence that the 31-year-old is just protecting his younger brother, who's 17. My client, because of the financial condition of family members, we believe that he's best positioned if the court were to grant a property bond. That would be, I think, the best way for his family to post a bond, just for the court's own knowledge and information. And my client does realize he does have a criminal history and the nature of the charges, and he is prepared to submit to a GPS ankle monitor and any conditions that the court would impose upon his release. He has many children. I get calls from many different family members and text messages on a daily basis. Many of them relate to his children. I get a lot of them for a very long period of time. So he has a very strong interest to go to the jobs that he has that basically consume the entire day and night to work to support his family. We believe the GPS ankle monitor would alleviate any concerns that the court has. Judge, and with that, we will submit to the court. Thank you.
Ms. Miller.
Judge, as Mr. Muhammad has said, this defendant is 36 years old. The facts of our case, the evidence we believe is a little different than what Mr. Muhammad has indicated. On July 11th, 2020, officers did respond to the residence of the victims at 4711 Wall Drive in Clayton County. At that time, they met with Jacurry Lawson, who is approximately 17 years old. He had a visible gunshot wound to his leg. They then attempted to speak with his younger brother, who was 14 years old at the time of the incident. Both of them advised they weren't sure what took place and were a little hesitant to speak with law enforcement. Jacurry was taken to the hospital. At that time, medical experts found a bullet had fractured his left tibia, and law enforcement then spoke with the mother of Mr. Lawson and his younger brother. At that time, she advised that they had both been afraid to speak to police without her present because they were afraid essentially of the defendant. Police did speak with them again and learned that what had taken place is the defendant had shown up at the residence looking for Jacurry's older brother, who was not available to speak with him. Jacurry asked him to leave the residence, told him multiple times that, he needed to go away, that this was their home. At that point, he turned away from the defendant. The defendant basically said something to the effect of, "I'm not leaving." Jacurry turned back around and at that time was shot by the defendant. The state contends that at no point in time did Jacurry have the firearm. At no point in time did he bring it out, although he would have been, justified in being concerned about the defendant's presence at his residence. But the defendant himself actually brought the firearm to the residence and then after refusing to leave, did point it at the 17-year-old child and shoot him in the leg. At that point in time, he did leave. Mr. Muhammad is contending that the older brother didn't give a statement to police. Our position is that the older brother didn't witness any of this take place. Only Jacurry and then his younger brother, who was able to see part of the incident because the door was open as Jacurry was speaking with the defendant, were witnesses to the incident. Both of them are listed as victims in this case. Your Honor, just so you're aware also of his criminal history, I know Mr. Muhammad did try to give a description, but I think he had some of his dates out of order. The defendant is a convicted felon. He has a 2004 burglary and obstruction from Fulton County. Following that, he had a couple of failure to appears out of Fulton County, one in 2005 and another in 2008. In 2011, he was convicted of possession of a firearm by a convicted felon, carrying concealed weapon, obstruction, involuntary manslaughter, which was downgraded from the initial charge of murder. He did receive a 20-year sentence, 10 of that to serve on that charge. Then in 2018, he was convicted of a misdemeanor. However, I believe that's relevant as it was a pointing a pistol charge, again, showing the defendant having possession of a firearm. And then in 2019, he had a misdemeanor drug charge. Your Honor, our position is simple. He knows where the victims live. He's been to their residence. He was at their residence at the time of this incident. We believe that there is a strong likelihood of him intimidating them if he is released on bond. They were already afraid to tell police what happened at the day that this took place. They are still very afraid of him, very concerned that he is going to come around and try to harm them again. We further believe that he is a significant risk of committing a felony if he is released on bond. Looking at his criminal history, he's shown a continuous disregard for the fact that he is a felon and not supposed to have a firearm. And so even just over the last, 2 years prior to this incident date, he did have another firearm charge even after the voluntary manslaughter and possession of a firearm that he was convicted of out of Fulton. And so with that, we do believe that he is a risk of committing another felony. We believe he's a risk of intimidation. With his failure to appear, we do believe, even though those were, in the early 2000s, that he is a potential flight risk facing these charges, with the recommendation that the state has on them, that he is probably aware that he is facing a significant amount of time in this case, and would be a flight risk. And so, Your Honor, with all of that, we're asking that no bond remain on his case. We do believe that there isn't a bond that could reasonably assure, the victim's safety and the community's interests in this case.
Mr. Muhammad, you have closing.
Thank you, Judge. Briefly, when the police arrived, there is no dispute that that the shot was fired, 911 called, the police arrived immediately, and the 31-year-old brother was there at the residence. And so he was there, and he's simply stating that he doesn't, he's not giving any information. Now, it's relevant that all of the brothers initially would not, they tried to act like some random person came and shot. And then when the mother came and stressed the point, she mentioned my client. But even then, so it's not that the 31-year-old just, isn't saying he wasn't there. That's not what his statement is. He's stating that he's not giving any information. He wouldn't even give information about the nature of he and my client's relationship, anything. He wouldn't discuss anything. And so we just believe that is, strong evidence with him being there and his 17-year-old brother being the victim, and my client's name already having been provided, that with him being there at the scene when the police arrived, that, my client's version of events, that he actually was there speaking to the 31-year-old is significant. And I just lastly just want to stress to the court the restrictions that we are asking the court to impose with regard to the ankle monitor and his ability to just work. And that's it. That's all that we're concerned with, because he does have multiple children. I do believe it's 8. I'll ask my client to shake his head if that number is correct. Okay, he's shaking his head. Yes, it's 8 children. And when I say that I get a lot of calls about him being able to support those 8 children, it is a fact that I want to stress upon the court, and he does have those 2 jobs waiting for him.
Okay. The court does have concern about the potential threat that Mr. Armstrong could pose to the witnesses in this case, and so therefore no bond will be granted. No bond. He's free to go back. Next case is Dantavius Wright for a plea. Are you Mr. Wright?
Go ahead, say it again. Yes, ma'am.
State of Georgia versus Dantavius Wright, case number 2021 CR 01037. Sir, raise your right hand. You solemnly swear and affirm the testimony you're going to give to be the truth, the whole truth, and nothing but the truth to help you God.
Yes, ma'am.
You can lower your hand. Sir, do you understand that you're before the court charged with false imprisonment, family violence, battery, and cruelty to children in the 3rd degree?
Yes, ma'am.
Ms. Miller, present the factual basis for the.
Your Honor, just so the court is aware, we're not seeking to proceed on count 1 on this plea. The summary for this case is that on August 25th, 2020, officers responded to Shell gas station in Clayton County in reference to a domestic incident which occurred at 1407 Dana Drive in Clayton County. At that time, they met with Dorinda Peak, who advised she was in an argument with her boyfriend, who is this defendant, during which he shoved her and took her phone, causing a visible bleeding cut to her chin. And Your Honor, that incident was witnessed by their juvenile child.
I'm sorry, give me a moment, please. I apologize. I'm not feeling well. Okay, Mr. Raleigh, I'm sorry, Mr. Wright. Do you have any major disagreement with the facts that's presented by Attorney Miller?
I found a restraining order on this particular female, and because of she likes to, tell, stories and stuff, and it's just she has a history of playing these kind of games. But
Okay, did I understand that you're reducing or changing one of the counts?
Yes, Judge, we were not proceeding on count one, so it would only be the 2 misdemeanors, the battery, family violence, and the cruelty to children.
Okay, sir, understanding that count 1 is being non-pros, counts 2 and 3, are you prepared to go forward on those 2 counts, having no major disagreements?
she's on me.
I'm sorry.
Yes, ma'am.
Okay, your attorney has provided to me a plea form. It is a written statement that indicates that you wish to enter a guilty plea pursuant to terms and conditions negotiated by your attorney and the assistant district attorney. Is that correct?
Yes, ma'am.
Did you read and sign the plea form and have an opportunity to discuss it with your attorney?
Yes, ma'am.
Ms. Rivera, do you certify that the statements contained in the attorney's certificate are true and that you properly advise your client of all rights as contained therein?
Yes, Judge.
And are you fully satisfied that your client understands the nature of the charges against him, the consequences of his plea, and that he freely and voluntarily tenders his plea to this court?
Yes, Judge.
Mr. Wright, are you offering your plea freely and voluntarily and of your own accord with full understanding of all matters as set forth in your indictment?
Yes, ma'am.
Do you have any questions about your case or your plea before I decide whether or not to accept your plea?
Will it'll be the 2 misdemeanors, correct?
Yes.
And
The first count is a felony. The state is recommending that that be not processed.
yes, ma'am. Yes, ma'am. Thank you.
Any other questions?
No, ma'am.
Are you a United States citizen?
Yes, ma'am.
How do you plead, guilty or not guilty? Do you plead guilty or not guilty?
I plead guilty.
The court is satisfied the defendant understands the nature of the charges against him, the consequences of his plea, and that he freely and voluntarily tenders his plea to this court. Therefore, it's hereby ordered the defendant's plea be accepted, and I order the plea form to be made a part of the record. What's the recommendation, Ms. Miller?
Your Honor, the state's recommendation is 24 months probation. That would be 12 months consecutive on counts 2 and 3. No contact with either of the named victims, a $500 fine or 50 hours of community service, anger management, attorney's fees, and probation fees.
Ms. Rivera, what does your client want to do, the community service or the fine?
We're going with the community service.
Now, as to the 2 victims as listed in the indictment in counts 2 and 3, Shantizia Patterson and Dorinda Peak. Does he have a relationship, a familial relationship with him?
Ms. Patterson was in a relationship with him. Ms. Peak is the niece of Ms. Patterson.
It's switched. Miss Peak is the ex-girlfriend and Miss Patterson is the niece.
That's correct.
Okay. All right. Sir, is that your understanding what the recommendation would be from the state in exchange for your plea?
Yes, ma'am.
Is there anything further from you, Ms. Rivera, on behalf of your client?
We just asked for credit for the time he's been in there. He's been in there for almost 8 months.
And that was negotiated?
It was from September 14th, 2020, Your Honor.
Sir, the sentence of this court, count 1 will be non-prossed. Count 2 will be 12 months probation. While on probation, sir, you will pay your $50 application fee for your court-appointed attorney. You'll pay your monthly probation supervision fees. You'll have to perform 50 hours of community service. And as to count 3, that will be 12 months probation running consecutive to count 2 for a total of 24 months that the court will sentence you to. And obviously you'll get credit the 8 months against that 24 months. You must stay away from the lady, the victims as noted in the indictment, Dorinda Peek, Darinda Peek, Peek, and Shortezia Patterson, Shatazia Patterson, Patterson, common spelling for Patterson. On your plea form, Ms. Rivera, you have anger management, but I didn't hear that as a recommendation.
It was a condition, Your Honor.
Okay. Sir, you also have to complete an anger management course as well. Do you have any questions about that sentence?
No, ma'am.
There may be other terms and conditions of your probation that you will discuss with a misdemeanor probation officer at the conclusion of court. You can have a seat, don't go so far because you'll be able to speak to somebody shortly. Now, position 5, Deangelo Barlow. State of Georgia versus Deangelo Barlow, case number 2020 CR 02005. Sir, raise your right hand. You solemnly swear affirm the testimony that you're going to give should be the truth, the whole truth, under penalty of perjury.
Yes, ma'am.
Okay, you can lower your hand. Do you understand that you're before the court charged with a single count of possession of methamphetamine?
Ma'am.
You understand that's why you're here?
Yes, ma'am.
Okay, Ms. Miller, present a factual basis for that single count.
Yes, Your Honor. On May 14th, 2020, this defendant was inside a store located at 7694 Terra Boulevard in Clayton County. At that time, he approached the store clerk, placed a small bag of methamphetamine on the counter, and stated, if someone comes in trying to kill me, please give this to them. He then proceeded to lock himself in the bathroom of the store, where law enforcement made contact with him and found him to look visibly impaired at that time.
Sir, do you have any major disagreement with the facts that's presented?
No, ma'am.
I'm sorry, give me 1 second. Your attorney has handed me a plea form or provided to me a plea form. It's a written statement that indicates that you wish to enter a guilty plea pursuant to terms and conditions negotiated by the assistant district attorney with your attorney. Do you understand that?
Yes, ma'am.
And on that plea form, or with that plea form, did you have an opportunity to review it, understand it, and have an opportunity to discuss it with your lawyer?
Yes, ma'am.
Ms. Porter, do you certify that the statements contained in the attorney's certificate are true and that you had an opportunity to explain the content with your client, to your client?
Yes, Your Honor.
And are you fully satisfied that the defendant understands the nature of the charges against him, the consequences of his plea, and that he freely and voluntarily tenders his plea to the court?
I am.
Mr. Barlow, are you offering your plea freely and voluntarily and of your own accord with full understanding of all matters as set forth in your accusation?
Yes, ma'am.
Do you have any questions about your case or your plea before I decide whether or not to accept your plea?
No, ma'am.
Are you a United States citizen?
Yes, ma'am.
And how do you plead, guilty or not guilty?
Guilty, ma'am.
Court is satisfied the defendant understands the nature of the charge against him, the consequences of his plea, and that he freely and voluntarily tenders his plea to this court. Therefore, it's hereby ordered that the defendant's plea be accepted and ordered that the plea form be made a part of the record. What is the recommendation, Ms. Miller?
Your Honor, the state's recommendation is a straight 1 year to serve with credit for time served. At this point in time, he's served over a year, so it would be a time served plea.
Anything further from you, Ms. Porter?
Nothing, Your Honor. We would just ask that you accept the plea.
The sentence is 1 year to serve, credit for time served.
Good.
You're free to go and prepare to be processed out. That concludes court for today. Is there anybody here that expected me to call a case that I did not call?
Yes, Your Honor, I would ask that you stay on the bench a bit longer, Ms. Mohammed, and I need to approach. I did send Your Honor a message in the chat and also said it to Ms. Jackson. And so It doesn't change my position, but there was something that was incorrect that was said, and I wanted to make sure I corrected that.
Okay, Ms. Jackson. You
I
said
think you meant Mr. Jackson.
You said
Well, I
it's
sent a chat message to Miss Kelsey Jackson, so she was able to get Mr. Muhammad back on the call.
Mr. Kelsey Jackson is a female, is a male in my office.
Oh, I'm sorry. I'm
Yes,
sorry.
he's my male calendar clerk. Okay,
I
no. So,
apologize.
all right, so is Mr. Muhammad on?
Yes, he came back on.
I'm back.
All right, as it relates to Dantavius Wright, who's on from misdemeanor probation?
I'm here, Your Honor, Officer Hill.
Okay, I'm gonna put you in a break